is the roll call. So if you'll, Ms. Akers, if you'll call the members.
Okay. Judge Kraft,
Present.
Judge Lauderback,
Present.
Judge Hudson,
Present.
Judge Harvey,
Present.
Stancil Ford,
Present.
Linda Byford is excused, Veronica Thornton.
Present.
We have quorum, sir.
Thank you. Let's see, I guess next one. The notice of the meeting, was that,
I have to read the statement of necessity, if you don't mind.
I'm sorry, I skipped that. Go ahead and read that.
According to TCA 844-108, if a physical quorum is not present, we actually do have a physical quorum, I think. Oh, we don't. We don't. Well, it's good that we had this. If a physical quorum is not present at the location of a meeting, the governing body other than the state debtor issue, the governing body other than the state debt issuer must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the state officer of the Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as the matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and the participation by a quorum of the members by electronic or other means of communication is necessary. This regularly scheduled meeting for the Private Probation Services Council. The purpose of this meeting, today's meeting via teleconference, is to discuss the rules and other normal business. There is, there is a couple of matters here on the agenda, including the director's report and the proposed rules. It's in the best interest of the council and all parties to have these matters resolved quickly. Waiting till the next meeting is unnecessary and puts all parties at a disadvantage by waiting 3 more months to have the proposed resolutions to their matters. If it's okay with you, I'll just read the notice of the meeting.
Go ahead and read the notice of the meeting.
Notice of the December 4th, 2015 meeting of the Private Probation Services Council was posted to the Private Probation Service Council website on November 17th, 2015.
Each of the members have a copy of the agenda. Not
I do.
that. Is there a
Yes.
motion, is there a motion that we accept the agenda, adopt that?
So moved, Mr. Chairman.
And a second?
This is Stancil Ford.
Second.
Call the vote, the roll call for the vote.
Judge Kraft,
Aye.
Judge Lauderback,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Judge Ford,
Aye.
Stancil Ford,
Aye.
and Ms. Thornton.
Aye.
Motion passes.
Take up now the minutes from the previous meeting, which was in June. I think the September meeting was not conducted, and with the last minute that has meetings would be from June. Is anyone not familiar with the minutes of the meeting? Motion that we adopt the minutes as they've been presented.
So moved.
That's Ms. Thornton. Is there a second?
Second that, Stancil Ford.
Call the roll for the vote.
Judge Kraft,
Aye.
Judge Lauderback,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Mr. Ford,
Aye.
Ms. Thornton.
Aye.
The motion is passed and the minutes are approved and adopted as they were presented. Next, we'll take up the legal report. Mr. Richardson, do you have something for us or someone in his behalf?
Yes, sorry, this is Ellery Richardson.
Oh, Miss Richardson, sorry. I was thinking of that detective guy named Ellery, sorry.
There are no cases that are currently ready to present, so there is no legal report for this meeting.
Pick up now we've had some proposals for a change in rules. So do you want to present anything about that at this time?
Let me hand out a red line version, and then this was also emailed out earlier.
those persons who are on the telephone, have you each had access to the proposed rule change?
This is just Kraft. I have them by email, and I've studied them.
This is Stansel Ford, and I have them by email.
Harvey?
Hugh Harvey, I have them also.
Okay.
All right, great. As you recall, we discussed these back in June, and the purpose came up that we had some situations arise where we realized that we needed some more rules to address some situations. So you have seen the initial drafts. We went over this in June. So I have a more finalized draft for you. The only change in Chapter 1 is the quarterly provider fee. We had discussed potentially lowering it, and a benefit of that is that it could potentially reduce some of the probationer's fees as well as the entity. I had our fiscal office look at it, and we do believe we can afford a reduction from $1 to 75 cents for every person reported on the caseload.
I'll vote on each of these changes separately.
I
Or do
think
you want to go ahead and talk about the second one?
I think it would be easier just to go through them all at once, if that's all right. So that's the only change for Chapter 1. So if you go on to Chapter 2, Rules of Professional Conduct, the first red line change is in 1177-2-.01, Duties and Documentation. So we would just add a D and E. Maintain and have available for counsel, court, and probation reviewing the following: schedules of fees, including a policy for indigent offenders, and proof of insurance and performance bond required under another rule. And this is something that they already have to have this for the counsel and the court, but just to clarify and state that you must have all these current things available. And then E would be, just clarification, understand that it is responsible for the actions of all employees, agents, and owners acting within the scope of their employment with the private entity. And if no one has any comments, I'll just keep going.
Well, this is just Kraft. If I can say one thing.
Yes.
On Section B, we eliminated the "and" at the end of that.
Oh, yes.
And we did not put an "and" after Section D.
Okay, thank you for catching that.
So I think we need to add the word "and" after Section D.
Yes. We'll add that in. All right. Okay, with that change, we'll move on if there are no more comments. The next change is down in Rule .04. I have changed the heading of that rule to be Conflict of Interest and Code of Professional Conduct. And then we had discussed about adding 4 additional rules there. So the first one would be no private entity that provides probation services or employee, owner, or agent of the entity may accept or give a gift, gratuity, or favor from a probationer, a probationer's family, or any person who offers the gift, gratuity, or favor with the intent of influencing the supervision of a probationer. And that's just general conflict of interest rule there. The next one would be number 6. No private entity that provides probation services or employee, owner, or agent of the entity may charge any fees not in the private entity's fee schedule unless ordered by a court or otherwise required by law. And then number 7, no employees, owners, or agents of a private entity that provides private probation services may engage in a romantic or sexual relationship or have any sexual contact with a probationer. No employees, owners, or agents of the private entity may use his or her supervisory position or influence to encourage, threaten, or force a probationer to engage in sexual activity. And number 8, all employees, owners, or agents of the private entity must treat all members of the court and the probationers assigned to it in a professional manner. Unprofessional treatment includes but is not limited to, and then there is a list of 5, engaging in aggressive, abusive, hostile, or disrespectful conduct, engaging in fraudulent or misleading behavior, giving any false impression of arrest authority through the use of his or her title or position with a private entity, collecting any money from probationers in excess of the private entity's fee schedule, unless ordered by a court or otherwise required by law, and engaging in harassment or discrimination based on race, national origin, gender, age, sexual orientation, or ability to pay. Are there any comments on those?
We're renumbering old paragraph number 4. Is that what that under?
Yes,
Okay. Just make that-
just a renumbering there.
Go ahead, then, with the rest of them.
All right, the next one is down in .06, which is refusal to renew, denial, suspension, and revocation of approval. And then we added 3 at the bottom there, starting with I, failure or refusal to follow its posted fee schedule, failure to follow the council's conflict of interest rules or code of conduct, failure to properly supervise a probationer as set forth in the probation agreement. And then we're going to clarify failure to properly supervise includes but is not limited to not meeting with the probationer as required, not conducting drug tests if those drug tests are required in the probation agreement, or not monitoring the probationer's attendance of any required counseling classes. And then the last change is in civil penalties. When you look in the civil penalty categories, violations involving conflict of interest and unprofessional conduct were not listed. It didn't specify which category it would be. So I just put them in the middle because I just had to put them somewhere. If anyone wishes to make them more severe, that I can move that there. I just put it there for discussion, so it would be in the rules. Are there any comments on that?
Looks very good to me.
So if we vote on this today, is this the final vote, or do you have to give out a notice?
What will happen is we would vote to approve these rules to go forward with the rulemaking hearing. The rulemaking hearing would take place at the next meeting, which will be in March, the first Friday in March. And I will go through with posting the notice and getting the notice of rulemaking out so the public is aware and they can come comment on these rules or any suggestions on these rules. So this would just be a vote to approve a rulemaking hearing for these rules.
What is the projected effective date?
After the rulemaking hearing, it depends on how many comments we receive. We would have to go through all the comments. The council would need to respond, decide whether they want to make any changes based on those comments. And then after responding to that, we would file the rule, and then it would take effect, I think it's 90 days after filing? 90 days after we were able to file. So it would be at some point in the later part of 2016, I would guess.
I have one thing that perhaps you can clarify it for me, somebody on the board can. Under section duties and documentation, the section D, the first item, including a policy for indigent defenders. That seems extremely, that's just common for the first page.
This is a policy they are already required to have. So we can go into clarifying exactly who qualifies as an indigent. I'd have to look. I know courts have their own determinations, but this is just a policy they are already required to have.
Comments or questions? Is there a motion that we adopt the rules as with the proposed changes?
So move, Mr. Chairman.
Is there a second?
Stand so forward.
Second.
Well, before I'll second it, and so I can ask a question. Are we adopting the 75 cents in this rather than the dollar? That's going to be the question. We really never discussed that. That would be one of the changes.
I think the rule or the motion would need to be clarified whether it includes all the rules,
Right.
or is there any discussion that council would
What
like?
I'm saying is we can pass the other rules, and then we can come back to the $1, or we can. I needed clarification on that.
So the current charge is $1.
Yes, the current charge is the dollar.
So, Judge Kraft, are you wanting to vote on that one separately?
That would be fine as long as that's. Yeah, I just wanted to make sure that wasn't one of the changes that was proposed yet. I just wanted to make sure it was clear, and I'll second that motion.
Okay, so just
Then we ought to back
Can
up
we-
a minute. Who made the motion?
yeah, let's restate the motion to clarify
Mr. Ford,
which rules.
would you modify your motion to
I will modify my
reflect
motion.
that it's to adopt the rules
In
except
chapter
for
two?
the fee charge?
I will modify my motion to that effect.
Second then. Judge Kraft?
Yes, I second.
Okay. Any other discussion? This is for adopting the rules as proposed, except for the rate change. Will you
Right.
call the roll then for the vote?
Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stetzel Ford,
Aye.
Veronica Thornton.
Motion passes. So now we'll move on to the proposed change about the rate change.
Yes,
The
that-
fee change. Is there a motion that we adopt that change?
Well, may I ask a question, Mr. Chairman? I'm looking at the last page that we received, and it says, right after the rules, and it talks about budget expenses $35,300, total expenditures $42.66, total revenue $33,575. So if we reduce it to 75 cents, we'll still be meeting our budget?
Yes.
Okay. I will make that motion.
Okay.
Was the motion?
Actually, the motion was already made. We'll just wait. Judge Kraft made the motion to adopt the proposed fee change. Is there a second?
From $1 to 75 cents.
75 cents. Is there a second?
Second.
Any other discussion? If not, call the roll.
Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stansel Ford,
Aye.
Veronica Thornton.
Aye.
The motion passed, and I'm sorry. Anyway, Attorney General, you can proceed with the rulemaking hearing.
All right, and I actually have one more item of business. I defer to the executive director whether I do that now as per my legal report or wait until new business.
We'll wait for the new business. So we'll move on now to do you have anything else other than that item? Okay. Sorry, Ms. Richardson, I lost your name there for a minute. Ms. Akers, you have a report from the director?
Yes, I have a very brief director's report this month. There's no legislative updates. Licensing counts, the private probation service companies totals this month is 35. The probation officers is at 200. The budget plan is at 35.3. Total expenditures as of October 31st was $4,266.60. And as of that date, the revenue as of that date, the total revenue was $33,575.05. I have included for your review the scheduled 2016 and the first meeting for 2017. And just to get your official approval on those dates, if you could make a motion to approve those dates.
So you ready for that? I still have some more to say.
That's really it.
Is there a motion to adopt her proposed schedule for the meeting dates, which would be the first Friday in January, March, June, and December?
It's
Good change.
Well, I've got a question. I'm looking here. March to May is just 2 months. And then from November 4th to January the 6th is just 2 months. So I'm trying to figure out what we're doing there.
Ms. Akers, traditionally, we just had our scheduled regular meetings were quarterly, and they were on the first in March, June,
Right.
September, and December.
first Friday.
September and December, right?
Yes.
But so we've rearranged those to where we're meeting 4 times in 10 months, and I'm just trying to figure that out. Usually it would be the first Friday in March, June, September, and December. Ms. Avers, do you understand what I'm saying?
Yes.
So we're not having quarterly meetings because there's only 2 months between March 4th and May 6th.
Right.
Let's do this. Judge Kraft, would you make a motion to help us move along, that our quarterly meeting scheduled for next year would be those first Fridays in those months, March, June, September, and December?
Absolutely.
In a second?
I second it.
Any other discussion?
You want me to change the dates?
Right. We don't want to meet 2 months apart. We're supposed to meet quarterly. So.
I'll try to switch it to June, but that means you'll be conflicting dates with CMA, and in June you'll be conflicting, competing for hotel rooms and such with CMA and all of the Bonnaroo people. That's one of the reasons I didn't book it in June.
Okay, but we've never worried about that in the past. So.
Okay.
Right.
So our motion is that the meetings be the first Friday in March, June, September, December. Is there a second, or was already one made? Judge, any other discussion? Call the roll for a vote.
Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stansel Ford,
Aye.
Veronica Thornton.
That motion is passed, so you can use that as your schedule for next year.
All right.
Do you have anything else in your report we need to take up?
Nope, that's all. I'll
All right.
get those dates revised.
New business, and Ms. Richardson, you had something you wanted to bring up, so at least we have one item.
Yes. I wanted to discuss briefly a Supreme Court case, the North Carolina State Board of Dental Examiners versus the Federal Trade Commission. It has some implications on state boards, so we are just briefly informing you of all of that. And I was not able to email this out beforehand, so I will send that out after this meeting is over, so everyone will have a PDF copy, but I have hard copy for the members who are here. So just as an initial matter, most of you are familiar with Westlaw cases. So there's the syllabus first. The actual opinion does not start until page 3, and then it actually ends on page 10, and page 10 starts the dissenting opinion, which, of course, as you know, is not part of the majority. But for those who are not judges, a refresher, though you probably already know that. So this was an antitrust case that the Federal Trade Commission brought against the North Carolina State Board of Dental Examiners. And so just the brief overview of the Sherman Antitrust Act states that any limitations on trade is unfair business practice and is illegal. Though states, of course, in their duty to uphold the public health, safety, and welfare, have immunity from that prohibition on restricting trade because they have that overriding public interest. And so states are given immunity so they can restrict trade for that purpose. And then, as all states set up boards to regulate different professions. And so the Federal Trade Commission brought a case against this North Carolina State Board of Dental Examiners for violating antitrust law, and the Supreme Court agreed with the Federal Trade Commission and said that state boards are not given immediate blanket immunity. They have to meet a certain 2-factor test to show that their immunity is met, and they're not subject to antitrust suits. And so it's a 2-part test. Any restraint of trade must be clearly articulated, and this restraint of trade must be actively supervised by the state. And the point of that is, the state is giving its immunity authority to regulate and restrict trade to these boards. So these boards can't just go out beyond what the state has already delegated their authority. What happened in North Carolina is, first of all, the State Board of Dental Examiners, those members were not appointed by the governor, as Tennessee is. They're actually elected by dentists. So only dentists get to have a say in who becomes a member of the board. I think there were 6 members of the board. 4 were dentists, 1 was a dental hygienist, and 1 was a public member. And so what happened, this board decided to go after teeth whitening services. They decided that it was the practice of dentistry, but there is a lot of, when you read the case, there's a lot of facts that come out that it was clearly anti-competitive. The whole point of doing this was that dentists saw a decrease in their market share. They got concerned about competition from teeth whitening kiosks. So they just sent out these blanket cease and desist letters. You can't do this. And the Supreme Court found that they were acting outside of the scope of their clearly articulated purpose of restraint of trade, and that they were not being actively supervised because they were just going out and regulating things that their enabling legislation did not say they could regulate. So that's the brief rundown. If you have any particular questions, just let me know. We can discuss it individually and just read the case. And if you have any issues, come talk to me.
Other new business to be presented from the board members
ahead.
or from the staff? Our next meeting then is in, what is this, December? Next meeting is scheduled in March. So, no other new business. There's a motion that we adjourn.
So move, Mr. Chairman.
All in favor, say aye.
Aye.
Then our meeting is adjourned.
And thank you for chairing the meeting. I'm sorry I had to appear by phone.
Take care, my little brother.
And I want to also just publicly thank everybody, Ms. Avers and everybody else. We're not having complaints, and it's because you guys are doing such a good job, and I really appreciate it.
Thank you. We'll be adjourned then.